Good day everyone, my name is Krishalin Pimang Ligmot and for today, we will discuss the law of obligation and contracts together with my groupmates, Ms. Mika Alcocero and Lugisa Astudillo.
So first, what is the law of obligation and contracts? It is one branch of private law under the civil law legal system. It is the body of rules that organizes and regulates the rights and duties arising between person with society. And laws on obligation and contracts are contained in the Civil Code of the Philippines. The first article is 1156. An obligation is a juridical necessity to give, to do, or not to do. An obligation is a legal responsibility imposed in any way that can result in legal action if violated. This means that everyone with an obligation arising from any source should fulfill it, taking into consideration the harm that compliance could cause to one of the contractual parties or even a third party. First is the obligation to give. The debtor must hand over the movable or immovable property to the creditor. The responsibility to deliver the item in sale, deposit, or donation is an example. Second is the obligation to do. All types of physical and mental labor or services are included. For example, include an event planning contract or professional services such as painting or modeling. And the last one is the obligation not to do. Implies avoiding certain actions such as building owner's responsibility to avoid causing a nuisance through loud, bad odors, smoke, and heat. Let's proceed to element of an obligation. Every obligation has 4 definite elements without which no obligation can exist. So first element, we have active subject. It is the one who demands that the commitment be fulfilled. It's also known as the oblige or creditor. Second is the passive subject. It is the one who obligated to offer, do or not do the prestation. It's also known as the debtor or the obligor. Third, we have object or prestation. It is the topic of the duty that has an economic worth or may be substituted for money in the event of disobedience. And last one, juridical or legal tie. The vinculum is what bonds the contracting parties together. Next, we have the sources of liability for damages of a party in an obligation are as follows. The first in line is fraud. The fraud is called incidental fraud because it occurs as a result of the fulfillment of a duty. In fraud, the objective is to avoid fulfilling the duty normally and to create harm. Second, negligence. In the context of contracts, common carrier, the lack of attentiveness or carelessness related to here is culpa contractual. Negligence is described as a failure to exercise the diligence required by the nature of the responsibility, as well as the time and place. And the last one is the delay. Individuals who are required to supply or accomplish anything face a delay after the specified deadline for fulfilling the obligation has passed and the obliged judicially or extrajudicially asks that the obligation be fulfilled. For Article 1157, enumerates the sources of obligation, namely law, contracts, quasi-contracts, delects, or acts of omission punishable by law, and last is quasi-delects. First, we have the law. A party's responsibility to fulfill obligation stems from the law itself. The taxpayer obligation to pay taxes is one example of this. Second is the contracts. It is the party's responsibility to carry out his contractual obligations. The party's obligation to pay for the extra number of people attending a catering event as agreed in the contract is an example of this. Third, we have the classic contracts. It's legal, voluntary, and unilateral conduct founded on the principle that no one should enrich themselves at the example of another. Then we have the 2 common forms of quasi-contracts. First, solution indebted, which is the payment by mistake where there is an obligation to return the payment. Next, the negotiatorium gestio, when a person takes over the management of an abandoned business without the owner consent, the obligation is to attend to the business until the undertaking and its incident are completed, or to call on the owner to relieve him of it if he also able to do so.
And fourth, we have the delects. It refers to duties deriving from delects or crimes that are governed by the revised penal code's provision on restitution, restoration of the damage caused, and indemnification of consequential losses, as well as the Civil Code's provision on damages, moral, exemplary, and nominal damages. For example, if a person is killed, the perpetrator is required to pay actual losses.
And the last one is the delects. Any act or omission that causes injury to another, even if there is no guilt or carelessness, and there is no pre-existing contractual relationship between the parties, is considered quasi-delect. The tortfeasor obligation to pay damages for injuries or damages caused by his fault, omission, or negligence is an example of this.
Mika Alcocer.
Diligence. Article 1163. Every person obliged to give something is also obliged to take care of it with proper diligence of a good father of a family, unless the law or the stipulation of the parties requires another standard. This article speaks of an obligation to care of a determinate thing. An obligor is duty bound to take care of a determinate thing which he is supposed to deliver to another. Otherwise, the obligations to deliver may become illusory because the obligor may not mind even if the thing be destroyed or lost. Indifference may characterize the performance of the duty to deliver.
Article 1231 obligations are extinguished by payment or performance, the loss of the thing due, the condonation or remission of the debt, the confusion or merger of the rights of creditor and debtor, the compensation and novation. Let me give you examples to illustrate the modes of extinguishing obligations. The first one is the payment of performance. In a restaurant, the visitor's commitment to the management who offered him delectable cuisine is discharged upon payment of the exact quantity of food consumed by the guest.
And the next one is an obligation deriving from a contract may also be discharged by the loss of the object due, provided the obligor is not at fault or negligent. The definition of the word lost was defined in Article 1189. It is accepted that things is lost when it dies, goes out of business, or vanishes in such a manner that its existence is unknown or cannot be regained. For example, in the case of a wedding being destroyed by a tornado in Marikina City, Metro Manila, the wedding organizer would be released from any duty to the couple. A fortunate incident, sometimes known as force majeure, is a legal concept that absolves an obligor of responsibility. Fortunate events are unforeseeable or unavoidable occurrences that could not have been predicted or that, even if anticipated, were unavoidable, according to Article 1174. This may be produced by two general causes. The first one is natural disaster including earthquakes, hurricanes, and floods. The second one is by men's actions such as armed invasion, bandit assault, and robbery. To be considered as serendipitous occurrences, human actions must have the force of an imposition that the debtor could not have refused. As a result, a party is free from obligation if a war breaks out and stop performance. Unavoidable accidents are considered fortunate events, even if human factors were involved, as long as the debtor is not held liable for any error or carelessness. If the item was stolen during a violent robbery, the debtor must demonstrate that he was unable to stop the crime. If the item is stolen, the debtor is deemed negligent for any living in a plain sight of criminals and not in a secure or safe location. As a result, the debtor will be held accountable for damages. Condonation or remission refers to creditor's act of liberty in which he or she forgives or remits a debt. Even though the owner owes his beef and chicken provide money, the obligation will be discharged if the supplier would freely offer the amount in question to the proprietor as an advance present in exchange for a latter's continued patronage of its products. Compensation means the offsetting of the respective obligation of two individuals who are primary creditors and debtors of each other, resulting in the extinguishment of their obligations to their concurrent amount is a way of extinguishing of an obligation. For example, Flora Hotel owes a sum of 80,000 to its linen provider. A month later, the linen provider asked 50,000 in culinary services from Flora Hotel, which the latter agreed to. The deal would have had the effect of erasing Flora Hotel's debt to the linen supplier up the amount of 50,000 only. The term novation refers to the alteration or modification of an obligation by another party, resulting in an obligation termination. Valid novation requires the following: the existence of a prior valid obligation, the parties' agreement to extinguish or modify the old obligation, and the new obligation legitimacy. For example, Argel, a singer, was hired by Ike, an event planner, for 2 wedding events planned in June. Ike handed Argel a 10,000 advance payment for the aforementioned events. Ike notified Argel a day before the wedding that the wedding dates would no longer be possible. In exchange of the cancelled events, Ike offered Argel 5 more wedding dates in July instead of returning the 10,000 to Ike. The same amount might be used as a down payment for Argel's 5 wedding days in July. Argel may no longer be obligated to perform during the June wedding ceremonies in this situation.
Other grounds of obligation extinguishment are not clearly mentioned in the preceding article. Obligations that are solely personal, such as partnership and agency, are extinguished by death.
Good day, my name is Tejessa Astudillo, and I'm going to talk about Article 1305 of the contract. Article 1305, a contract is an agreement between two people in which one of them commit to giving something or performing a service for others. And definition of contract is given in this article. A contract of adhesion is one in which partially all of the conditions were written by the single party, typically a corporation or insurance firm. The other party's only contribution is the affixing of his signature or adhesion. Uptakes contracts are not obviously invalid, but they are legally enforceable as any other contract. The Supreme Court has declared adhesion contract illegal where the weaker party is forced to take it a leave in a dealing with the dominant bargaining party, denying them the ability to bargain on the equal basis. Characteristic of a contract. The first one is mutuality of contract. Mutuality of obligation in contract refers to requirements that all parties involved in contract agree to the same term. The second is autonomy of contract. The autonomy of contract allows the parties to establish such stipulation clauses, terms, and conditions as they may deem appropriate, provided only that they are not contrary to law, moral, good custom, public order, or public policy. The third is relativity of contract. The principle of relativity of the contract affects means that the contract can generate rights and obligations only in favor of or regarding the obligation of the contract parties, as well of persons who become parties after closing the contract or assimilated to the parties. The fourth is consequality of contract. The consensual contract is a contract that is founded on the mere unanimous agreement of interested parties and doesn't need to be implemented through an official procedure. The last one is obligatory force of contracts. Obligations arising from contracts have the force of law between the contracting parties and shall be the complete with good faith. This one is actually under the law on obligation. Obligation either arise from law or contract, and they are juridical necessities. Contact stage. These are the stage of contract generation. It is preliminary stage of procedure for contract formulation. It entails negotiating the subject of responsibility as well as consideration or causes. Perfection is the birth of the contract. Consummation. It is the achievement of contract original goals. Defective contracts. The defective contracts are found in Article 1380 to 1422 of the Civil Code. Rescisable contract. It is a law contract since it meets all the legal requirements, but is defective because it caused injury or damage to one of the contracting parties or third parties.